And welcome to Outside of the Box, developing a legally compliant and effective criminal history inquiry. I'm Mike Coffey. I'm president of Imperative Information Group. We're a background screening company based in Fort Worth, serving clients all over the country. I'm an HR guy. I've been in and around HR for more than 20 years now. I'm real active with my local SHRM chapter. I'm a past president, and I'm also on the state council for the Texas State Council of SHRM. I'm also proud to be a board member of the Texas Association of Business, which is basically Texas's state chamber of commerce. And I've been really involved in a lot of issues in our industry at a national level, including starting a group called Concerned CRAs, which is a consumer protection grassroots organization trying to improve the consumer protection in the background screening industry, which sometimes isn't as high as we'd like. But what I'm not is a lawyer, and I'm especially not your lawyer. So you're going to hear some stuff today that's definitely the gospel according to Coffey. These are my opinions and things that I've figured out over the last 20 plus years of working with employers. I do want to encourage you, though, whatever you take away from this, take it back to your lawyer and talk to them. There may be reasons that you're not even aware of, that your company does things a certain way. I would suggest to you that a lot of what you're probably doing in the area we're going to talk about today is either driven by concerns in states where you're not even operating, or by things that you've inherited and no one's really considered thoroughly in a number of years. So just because you're not doing it the way I do it doesn't make you wrong, but it doesn't make me wrong either. So just go ahead and if there's something that intrigues you today, let's just take it back to your own legal counsel. Let's do a real quick poll. I want to know, when do you ask your applicants about their criminal history? And let me launch this real quick. And if you'll just take a minute to share that information with me, I'd appreciate it. Okay. Wait till at least 3/4 of you have voted at least. We're about a half now, so go ahead and click it. I got all day, so if you don't want to participate, we'll just sit here. But no, okay. At 62%, is that as good as I'm going to get? Okay, well, I'll go ahead and close it now. Okay, well, of those who responded, you'll see that 58% of you ask on the employment application. About 12% of you ask after the first interview, and 1/4 of you ask about applicants' criminal history post-offer. And a few of you never get around to asking, or you ask it some other time. So that's not uncommon. I usually have, depending on where my webinar population, or especially when I'm speaking at a SHRM conference someplace, it tends to be heavily influenced by what the local regulations are wherever somebody operates. We're going to get into some of those regulations here today. So 65 million Americans have some sort of criminal history, about 1 in 4 adults. Now, that doesn't mean that 65 million Americans have criminal convictions. What it means is 65 million Americans have had some interaction with the criminal justice system. And groups like the National Employment Law Project and other groups like that are really advocating for people with criminal histories tend to over-exaggerate what employers' policies are, and they basically put out there the suggestion that 1 in 4 Americans is completely unemployable because employers are being unreasonable in their use of criminal history. My experience in dealing with employers all over the country for the last couple dozen years is that that's just not the case. Employers tend to be very nuanced, and what they certainly don't want to do is make it harder to hire to fill an open position. And so we've come a long way since the days of the Missouri Pacific case in 1975, where employers just had bright line rules and just flat refused to hire anybody with any criminal history at all. Now, people's criminal history does either eliminate them from consideration for certain kinds of jobs, or just makes them a less positive, a less likely candidate than another candidate. So there's really two ways that employers use criminal history. The first is, quite honestly, as an exclusion, right? That's a bomb on the right, and that's a bomb on the left too. And so, this guy here in the picture on the left may not be the person that you want driving the forklift in your munitions factory. So somebody with a recent DWI probably shouldn't be operating a motor vehicle for you, operating heavy equipment in your warehouse, or maybe even operating dangerous equipment inside of your plant facility. And you can think of other exclusions that may be more applicable to your environment, but there are going to be certain kinds of criminal offense that are relatively recent that just outright exclude somebody from a certain kind of job for a certain period of time. Now, we've got a whole webinar on that topic called how to create a criminal history evaluation tool. It's recorded on our website. I believe we're giving it actually that presentation next month as well. So you've got some opportunities to look at the tools we've developed for employers in that area. But clearly there are going to be some instances where an employer is either just flat excludes somebody because of their criminal history, or where the criminal offense is directly related to the job enough that the employer is going to say, give me more information about that. They'll ask more questions of the applicant about the information, and then go back to the background screening company and verify with their background screening partner the information that the applicant provided. For instance, a good example of that is a simple assault. Somebody had a simple assault 3 years ago. Does that exclude them from working in your organization? Well, it might. Most employers would probably want to know what exactly happened. Was this when the guy was in college and he was at a party and things got out of hand and he was in a fight and he punched somebody, but it wasn't that big of a deal? Or was this a case where somebody was at work and they got into an altercation with a coworker or a patron, and they punched that guy out? That'd be a bigger concern for me for certain kinds of roles. And so maybe sometimes the employer needs to know more detail about what happened, but always verify what the applicant said. So sometimes it's exclusionary, or at least it's of concern and we're going to dig deeper. But other times we just use that information like we do everything else we can learn about the applicant to evaluate candidate A and candidate B. So what you get in a situation like that would be the guy on the left, applicant A, he's got some sort of criminal history. Equally situated candidate on the right, same experience, skills, education, but he didn't have any criminal history. And so depending on what applicant A's criminal history is, that may cause you to evaluate between applicant A and applicant B and choose applicant B over applicant A. Again, depending on what the criminal history is, but it may not, none of it may be even, the criminal history may not even be directly related to the job, but it may tell you that this person is not going to be your best candidate. So let's look at this. Let's see how this plays out. We've got Dick here, and Dick has 9 years of relevant experience. He's got an MBA. He's got very neutral job references. Everything he's told you was verified. He performed well during the interview, and he reported no criminal history when you asked about it on the application or at a later point in the process. Now we got Tom. Tom is just, he's very similar to Dick here. Performed well during an interview, but 2 years ago we had a theft by check conviction, which is kind of a red flag, because really to get a conviction on a theft by check means that you were told about it typically and you just refused to take care of it. Then in 2011 he had an open container violation, so he had a open alcohol container either in a public place or in a motor vehicle or something. In 2009 he had a failure to appear. So he was supposed to appear in court, maybe on a ticket or something, and he just didn't show up, and he got a conviction for an FTA. Now, none of these are things that would necessarily exclude somebody from employment, but if you're evaluating applicant A, Tom, and applicant B, Dick, against one another, who's going to be easier to manage? Which one of these two candidates is telling you, hey, I'm the guy that's going to take up all your management time and all your I'm going to be your employee relations issue? I'd suggest it's probably Tom. And we see this a lot with applicants with, just these consistently minor, petty criminal offenses over and over and over again. Well, they're telling you, this is how I behave. And this may not be your most compliant employee when it comes to following your company's policies and procedures and doing the things that you want them to do the way you want them to do it. So, and what we do often is we hire for skills. We've got these great knowledge, skills, and abilities, these competencies we developed for our jobs, and we hire against those. But what do we fire for? We fire for behavior. And isn't it true that, the whole point of behavioral event interviewing is to determine how past performance predicts future performance. And so if their past behavior is indicative and apparent to an employer, then I would suggest that maybe that's going to help you to determine how they might act in your environment. Now, it's not an exact science. Certainly it's not. And it's really important for employers to try to be fair. But at the same time, you don't owe everybody who walks in the door and applies for you a job. You, as an employer, your job is to find and staff a safe and productive workforce. And sometimes people are identifying to you when they respond to your criminal history inquiry or through the background check that maybe they're not your best choice when it comes to that. And so what does bad hiring cost? There's all kinds of numbers out there. The Department of Labor says that a bad hire for a management position costs the company 150 times the annual, or 150% of the annual salary that you would pay for that employee. There are other studies out there that say it can be as high as $750,000, $800,000. And when you think about it, you've got all those initial recruiting costs and all of those things that you bring somebody in the door for, but then after they're in the door, what's the impact on the people they work with while they're being trained? You've got a new person who's not productive yet, and it tends to affect the productivity of those around him or helping him get oriented. It definitely affects the productivity of your management as they're getting the person up to speed. And then if the person's behavior is such that you end up having to manage them a lot more, there's a lot more management cost. Then you've got to manage them out of the organization, and there are a lot of costs related to that. And then you got to start the whole process over to replace them. So there are a lot of costs there. Then there are costs that we don't often put hard numbers on, but what's the cost of a damaged relationship with a customer or a missed deadline, things like that. And so those kinds of costs should also be considered. So the bottom line is we all know we need to make the right decision the first time. And part of that is knowing as much as we can about the applicant. We have a website called Bad Hire Days at badhiredays.com, and it's full of stories about real applicants who were hired by employers who didn't know about their background, never asked, or the applicant lied about it. And when the employer found out about it, it was too late. They'd already hurt that employer. So if you're interested in those kind of anecdotal stories, go to badhiredays.com. But the truth is, your concern as an employer is predicting how an individual's past behavior will predict their future behavior. And so we'll talk about some things today that will help you do that as you design your criminal history inquiry. But let's just keep that in mind throughout. What we're really interested in is what did this person do? What conduct did they engage in that might be reflective of how they'll manage business when they work for us? So what you don't want to do is ask a criminal history question that's too narrow or overly broad. But what you do, there's a national movement that we need to talk about that's called Ban the Box. And the idea behind Ban the Box is that employers should not ask about criminal history on the employment application. In most cases, Ban the Box removes the criminal history inquiry from the application and delays it until after an interview has been conducted. In some cases, it delays the criminal history inquiry until much later in the process after a conditional offer of hire has been made. Now, the underlying idea behind this is that you as an employer cannot be trusted with this information, that as soon as an applicant applies, you will throw that application in the trash and if they've admitted any criminal history. my experience is that most employers worth their salt, and certainly those who want to stay in business and keep a fully staffed workforce, they don't do that. However, there doubtless are some knucklehead employers out there, or at least some hiring managers who have biases. And I really encourage you to check those biases, and that's why our creating a criminal history evaluation tool webinar is so important, because ideally you'll know as soon as the application documents turned in and you see their response to the criminal history inquiry, you'll know immediately, you know what, with this criminal history in this, this recent time period, this person just isn't eligible for this particular job. Maybe we can put them in a different job, but we can't put them in this one. Or you'll know that we will need more information. We'll have to talk about this during the interview if they're a successful candidate. And then in some cases, you'll just see the criminal history and say, according to our policy, that particular criminal offense isn't of concern. So we've got a whole webinar, and I've got a whole bunch of tools we've developed for clients to help put that together. But and I suggest you go look at that. But today we're going to just primarily focus on the criminal history inquiry. And this ban the box movement is basically saying you can't be trusted with that, employers. So you should have to interview the applicant first, and maybe the applicant will be so charming that you overlook their criminal history. And I would advise you that in no situation should an applicant's charm override what you've put together in your well-conceived employment policies. And we just put a blog article out yesterday on our website about that issue and about what that process should look like. But ban the box is gaining momentum. Currently, I believe there are 16 states, the District of Columbia, and more than 100 municipalities. So this isn't even just a statewide issue. This is often city by city where they're putting their own ban the box requirements in for employers. Now, most of these are ban the box or fair hiring laws where they affect only government employers. But a handful of the states, and we'll talk about them in just a little bit, do have limitations on private employers too. The great news is that the state of Texas doesn't have any of those limitations, and that's where we're based. And if you're a single state employer or you're only operating in a few states, you may not have to worry about it. If you can go look at those few states and say, those states you're operating in, say, well, they don't have any ban the box ordinances or laws, or even in the municipalities where you're hiring out of, they don't have any of those limitations, then you're probably fine with just keeping the criminal history on your employment application. However, we're seeing more and more multi-state employers move to a multi-state approach where they go ahead and they just accept ban the box up front, and they take the criminal history right off the employment application. In most cases, they have a criminal history inquiry document, and I'll show you the one we have in just a second, that they give applicants after an interview, or in Hawaii or the District of Columbia after they've made an offer. And now, like I said, there are now 16 states that have some sort of restriction, but a lot of those are just for public employers, not private employers. But a handful of states, Illinois, Massachusetts, Minnesota, New Jersey, Rhode Island, have limitations on public employers, plus Hawaii and District of Columbia as well have them on private employers as well. So what does your criminal history look like if you're a multi-state employer and you're dealing with all the state-by-state caveats? Looks like something like this. This is the criminal history inquiry we give clients. And we'll go through the pieces of this in just a second, but to do it thorough, if you're a multi-state employer, what you end up with are all of these little exceptions out here for California, Connecticut, Georgia, Massachusetts, all these special cutouts from your main criminal history inquiry, because not only do these states have, many states have banned the box, they've also got specific limitations on what an employer can even ask about or consider. And so you want to make sure you're aware of that stuff when you're crafting your criminal history inquiry. And again, if you're just a single state employer operating just in Texas or just in Colorado or whatever, you can really hone down your question just to ask what you can legally ask in that state. But as you become a broader and broader employer and you're hiring for positions in multiple jurisdictions, then you have more and more concerns. So we'll go through some of those in a bit. So let's look at just the basic criminal history inquiry, this document that I showed you a moment ago. And let's just go down. This is I want to apologize right up front. I hate slides that are full of text. But I just haven't found the right pictures to replace what the text says. So what you're going to see on the next several slides are just the content in our sample criminal history inquiry. Hopefully that'll be, and certainly please do, we're going to send you after the webinar a link to download the slides, and the slides will have all my notes from each slide on them, as well as a copy of our criminal history inquiry that we suggest employers start from when crafting their own. So the first thing you want to tell the applicant is, hey, just because you've had some interaction with the criminal justice system doesn't mean that we're going to exclude you from employment. We're going to look at the nature of the offense, the time that's passed, all those green factors from the Green versus Missouri Pacific Railroad, and your whole background. We're going to look at the full applicant when you're applying. So just because you've had a criminal history won't necessarily exclude you. But at the same time, it's good to tell them this right up front so that you're not dissuading applicants who see, oh, well, they're asking about criminal history, they're not going to hire me. Well, no, you're telling them right up front that we're not going to automatically exclude you. And that's important because most of the litigation that's going to arise out of your criminal history inquiry, if it's not for violating some state's limitation, is going to be, they're going to claim that it's a Title VII violation, that your overly broad use of criminal history is excluding applicants from applying, or excluding applicants from being hired, and those applicants happen to be disproportionately in a protected class. And if you get investigated, if there's a claim made and you get investigated by the EEOC is going to come in and they're going to say, look, your criminal history inquiry is right there on your employment application, and the way you asked the question dissuaded people from applying for the job. So it's really kind of important right up front to say, that the disclosure of prior involvement with the criminal justice system is not going to exclude you automatically in and of itself. And that's basically the results of the Green versus Missouri Pacific Railroad case. And we talk about that one, that case in another webinar called, what's it called? Background checks under fire, and how to develop a policy, a criminal history policy that doesn't lead to discrimination claims. The next thing you want to make sure that they understand is, if you lie to me on the application, if you don't answer my fully legally submitted question, then you're going to be disqualified from consideration as a candidate. Or if you're hired and then we find out that you lied to us, you're going to be terminated. And that's ideal, because really, if somebody lies to you on the employment application and they come in, if they walk in the door lying to you and you accept that, can you be really surprised later on if they, either they lie to you when something else goes wrong, or they just don't tell you about it. I mean, if they're not proactive, and if they think they can get away with this, or just overlook the question, or write "we'll discuss" on the criminal history inquiry, then those kinds of issues, they're telling you, hey, I'm going to be a person who's not very compliant. I'm going to be a person who doesn't follow company policy and procedure when I don't think it suits my best interest. So make it really clear, and we encourage all our clients, at least, to have that last sentence there. This company conducts thorough criminal background checks. So you're telling them right up front, hey, we've already told you we're not excluding you automatically based on your criminal history. And secondly, if you lie to us or you don't disclose everything that we ask you to disclose during this criminal history inquiry process, then you're going to be eliminated from consideration. And just one last warning, we do a really good background check. So it's you're not going to, and I hear all the time from consumers or applicants who call me and they're really mad about their background check. And after I talk to them, they're not mad because it was incorrect. They're mad because it was correct. And they'll tell me, look, I've applied for 3 other jobs, and I've had 3 other jobs since that criminal offense happened, and it's never shown up on my background check before. And I mean, my answer is, well, those employers weren't using us. They weren't using as thorough a background check company as we are. And so, I don't have much to say beyond that. That's the difference between a cheap background check and a good background check. So the next question we suggest that you ask in this process is ask if they've ever been sanctioned, excluded, or otherwise prohibited from participating in any healthcare or financial related or government procurement programs. And the reason for that is if you're a government contractor, or if you're providing any kind of a healthcare service that you get Medicare or Medicaid on, there are prohibitions out there in many of your contracts from hiring people who've been previously debarred or suspended from participating in those kinds of programs. And so you probably don't have it any place else on your employment application, so why don't you ask the applicant right up front if they've had that, so that they can give you the details of what happened, and then you can evaluate if it's relevant to the job. This is something I don't see on many applications, and we encourage our clients to include it in the criminal history inquiry. And then we get into the meat of it. What's the criminal history question we ask? Well, first of all, it's not a question. I see a lot of applications with questions like, have you ever been convicted of a felony? Or have you been convicted of a felony in the last 7 years? Those kinds of things. And I think those are really narrow questions. And what we ask is, we just want you to list all misdemeanor and felony criminal matters. And I would suggest to you as an employer, and we talk about this a lot more in the criminal history evaluation tool webinar, but I suggest to you as an employer that you really don't care so much whether an offense is a misdemeanor or felony. What you care about is the underlying conduct. That's why you are concerned about putting this person in this job, is what they did, not the fact that this state classifies it as a misdemeanor or this state classifies it as a felony. And we see that from state to state. What's a misdemeanor in Texas may be a felony in Oklahoma, or what's a felony in Texas, in fact, statutory rape, an adult having sexual relationship with someone underage in Texas is a felony, but in Louisiana, there's a classification of that is a misdemeanor. And so I think in certain environments, you'd be concerned about it either way, misdemeanor or felony, just because one state's legislature decided to call it something different. I'd suggest you really want to be more concerned with what they did rather than whether the court called it a misdemeanor or felony. And then the next thing we suggest is that you look at the information regardless of age. Unless you're in a state that limits your consideration of criminal history, limiting it just to 7 years or 10 years doesn't always make sense, because you don't know what the person is going to tell you. If they told you they were convicted of sexual assault or rape 10 years ago, and you only, is that going to be relevant to your consideration? It might be for certain jobs. And I see a lot of employers who are limiting their inquiries and even their background check to 7 years of criminal history. And there's nothing in federal law or in most states' laws that limit that. We'll talk about the few states that do have some sort of limitation in a bit. So we recommend you tell the applicant, tell us about everything. You've already told them you're going to be fair in your evaluation and you're going to look at the whole applicant, and the further back the criminal history is, obviously in many cases the less relevant it is. But if somebody was convicted of murder 20 years ago and they've only been out of prison 3 years, if you only ask about criminal convictions in the last 7 years or the last 10 years, you may never know that they were actually in prison for that time. So we recommend asking a very broad question where you can legally. That doesn't mean you're going to use it, but you don't know whether it's relevant or not until you get the information. And then we tell them regardless of outcome too. So it's regardless of age and regardless of outcome. Because again, somebody was convicted of a criminal offense, that's one thing. You can definitely assume that they engaged in that conduct. But there are other situations where just asking about a conviction will miss information that you care about. For instance, in most states, there's some sort of outcome in a criminal case called deferred adjudication. And in those cases, the defendant pled guilty or no contest to the offense and accepted punishment for the offense. And so they pled guilty or no contest, accepted punishment, which is typically some sort of probation. Maybe they had to attend anger management courses. Maybe they had 5 years of probation and they had to go visit with a probation officer on a regular basis, or go submit to drug tests on a random basis, something like that. So they've admitted, or they've accepted responsibility for the outcome of the case, for the underlying conduct. And now, but what happens is in these deferred adjudications is once they've completed the probation successfully, the case is dismissed. So if you're only asking about convictions, you may not know that this person was, just completed, 3 years or 4 years, 5 years, or is still on a deferred adjudication probation for some sort of offense, including assault. You can get deferred adjudication in Texas for a wide range of offenses, including violent offenses such as assault and things like that. So I think you would want to know, and so you want to ask more than just how the case came out. Was it just a conviction? We want to know. We want you to tell us about every case where, if it was filed, and we will decide. We'll get more information and decide if it's relevant. That's your job as an employer, not the applicant's job to determine whether it's relevant or not. And we also want them to tell us about any active cases. If they've got a case filed, and you only ask about convictions, and they're currently facing a case for some sort of criminal offense, I think you want to know about it. For a variety of reasons. You can look at what they're charged with, and I suggest that if they were convicted of that charge and it would eliminate them from consideration, that you tell them, you know what, we need you to go take care of this, and then, if we've got a position open after it's been taken care of, we'll re-examine you as a candidate if you'll apply. But in many cases, we're not going to take the time of training you and spending all that effort to bring you on board, with the chance that you're not available for work in 3 to 6 months for some period of time, or that a conviction would be found and you can't, you're not available for work, or the conviction would eliminate you from consideration. So we want them to tell us up front. And there may be cases where, somebody, if they're driving a desk in your organization, they never leave their desk, and they've got an active DWI case against them, and you say, you know what, you don't ever drive, you don't operate any dangerous equipment, we don't care about that DWI. In and of itself, it wouldn't eliminate your work conviction, so we'll go ahead and hire you. But you want the applicant to tell you about it up front. We want you to tell about us all cases in which they were charged, again, not just convictions, or for which they participated in a pretrial diversion or some other program to avoid prosecution. Because there are situations in some jurisdictions where you can basically enter into something similar to a deferred adjudication, but the case is never filed or never prosecuted, and those are often called pretrial diversions. So before they ever went to court, you agreed to serve some sort of probation. And so we want to, this question here, or this paragraph, doesn't give them any wiggle room. There's nothing that you can fairly consider that the applicant can avoid telling you if you ask a really thorough question like this. And then we also want them to tell us about any registrations they have for sexual offenses or violent offenses, except where the case was expunged, annulled, or erased, where you couldn't go get the case anyway. And the reason that matters is there are cases where in some jurisdictions somebody's required to register for a sex offense, or they're on some sort of violent offenders registry, but the underlying case is not available. We saw this recently with a client who had an applicant who showed up as a registered sex offender. It was a 21, 22-year-old male. And we dug around and we could not, to save our lives, find the underlying case. And what had happened, he was registered as a sex offender for an offense that happened when he was under 17 years old. And so his juvenile case in the county where it was filed was sealed. So we could not, we couldn't find the underlying sex offense case, but we did find that he was a registered sex offender. And there may be certain circumstances and certain jobs in your organization where somebody's registration as a sex offender would eliminate them from employment. And if so, you should probably ask right up front for them to disclose that to you, because the idea is that the background check should show no surprises. You've asked the applicant a really thorough question, and so now what you're waiting on is for them to tell you the truth. And then the background check is just a lie detector test, and it verifies that they told you the truth in the perfect world. And then if they've had any arrest in the prior 12 months, and then, so tell us about those. And then do you think there are going to be charges filed, or what's happened in that case? And again, you're not using that information in and of itself to make a decision, but it would be an indicator that, hey, we need to go get more information and understand what's really going on here. I hear from employers a lot, even here in Texas, where they say, well, it's illegal to consider arrest information. And it's not. In Texas and in most states, it's not, and it's certainly not under federal law. Even the EEOC, in their guidance for employers, has said employers can use arrest records if they go further and determine that it's reasonable to believe that the individual engaged in the underlying conduct. Now that's kind of a lot of words, but the idea is if somebody was arrested and there's a case active against them, or if they were just arrested, and we're not asking just about arrest, we're only asking about arrest in a very narrow period of time. But if they did engage in that conduct, as an employer, what you should do is go back to your background screening company and say, here's what the applicant told us. And they told us, there's no case filed and nothing's ever going to come of this. Can you go find out, get them additional information, pull police reports for us or whatever? Because here's what happens sometimes. You'll see multiple cases where people have been arrested for assault and bodily injury of a family member, domestic violence. You see that, and then you see the case was dismissed at the request of the complaining witness. And so what happened? Friday night, he comes home drunk and he's beating her up. She calls the police to get him off of her. The police show up and they put in their report. They showed up. She was crying, had a red splotch on her face where it looked like she had been hit. He was yelling and screaming and really belligerent with the police officers. All those kinds of things, and those are all in the police report. But then what happens? Sunday rolls around and she realizes maybe she's got to make their rent this month, or she just loves him and she feels bad about it or whatever. And she goes down and refuses to prosecute and refuses to cooperate with any kind of prosecution for him, and they dismiss it at the request of the complaining witness. You see 2 or 3 of those in a row, and that's a pretty good indicator that maybe this isn't the best person to put on the customer service desk at Target the day after Christmas, right? This is somebody who's, consistently we've seen this kind of alleged behavior, and it's reasonable for me as an employer to believe there's something going on here. And that's what the EEOC's guidance says, is that you should look at it to see if it makes sense and if it's reasonable for you to believe they engage in that conduct. And if so, then use that information in making the hiring decision. Just the fact of an arrest doesn't prove that the person engaged in that conduct. But if you get deeper into the circumstances surrounding it and collect more information, it may make more sense for you to believe that they did engage in that conduct. So that's why we ask. Then we go ahead and tell them, exclude any sealed or expunged, annulled, or erased records. A bunch of states already have on their books limitations on employers' ability to look into those. And if a court has said this is sealed and not for public fodder, whatever the applicant tells you, you're not going to be able to verify anyway. It's going to be really challenging for you to verify it because you can't get into the courthouse. Your background screening company can't go into the courthouse and dig that record up. So you want to, just tell them right up front, don't tell us about those. And then you don't care about, in most cases, unless you're hiring a driver, you probably don't care about minor traffic violations where there was no arrest made. Now, if this person's operating heavy equipment or a motor vehicle, something like that, some sort of dangerous equipment or machinery, then maybe you want to know. Maybe you want them to have it. And I do have a client who has the applicant list all the criminal offenses or all the traffic offenses they've had for the last several years on the application. So it may be in your environment, it makes more sense to go ahead and ask them to include that information. And then you've got all that, and then they answer, they give you, you've got two options here. I have no criminal history that you, as described above, or the full accounting of all this information is listed below. And what you want them to do is give you the dates, where it happened, what the offense they were accused of was, and what was the outcome, and any, if applicable, any sentencing on that. That way, you leave it right there and you tell them exactly what you want them to give as a minimum, and they give you that information. And it should be a red flag if an applicant says, I don't remember, or someplace around, someplace in, North Texas or something like that, because, first of all, anytime an applicant's unwilling to provide information on the application, or they're too lazy just to go find the information and provide it, makes me crazy to see employment applications where the applicant's too lazy to look up the employer's phone, the prior employer's phone number. That's just, first of all, it's a red flag to me that this person's probably not somebody who's going to be my hardest worker. And secondly, that, they really don't want this job. If they really wanted it, they would probably take the time to fill that out. So also, let me just tell you, go ahead and if you have questions, ask them, type them in the question box, and we will deal with all of them before the webinar is over. So that's our criminal history inquiry. Now, I've got like I said before, I've got a whole webinar on avoiding discrimination claims in the use of your criminal history. And one of the things the EEOC put in their 2012 guidance for employers on the use of criminal history is this idea that you should have an individualized assessment. Basically, what in the EEOC guidance, what they want you to do is give the applicant a reason or an opportunity to explain why your policy shouldn't apply to them. And so to give you additional information about the context around their criminal history or what they've done since then or whatever. So, and you don't have time to have this conversation with every applicant who's got some sort of criminal history. So what we suggest is that you go ahead and build that into your employment application or your criminal history inquiry. And you just say, hey, if you don't think this information adequately reflects the circumstances surrounding the offense, or you think there's additional information that we need to know to understand this, provide it here. And that way you've got it built in right into your employment application, right into your criminal history inquiry whenever you ask. And that way you've given them that opportunity right up front. So down the road, they can't claim, well, they weren't fair because they didn't consider this additional information. Well, we asked for it and you didn't provide it. And I'll tell you, my clients who are using this say that they almost never get any additional information provided by applicants here. Because often I don't think there's a lot of additional information other than the black and white of it that an applicant can share that would really be relevant. So let's talk about some state-specific concerns when we're talking about criminal history. And if nothing else, it'll make you glad you're in the state you're in. California, you need to ask your applicants to exclude, when they're disclosing all this information, any information about marijuana offenses regarding less than 28.5 grams. So, minor marijuana convictions that are over 2 years old. And then if also in California, an employer can't consider a non-conviction criminal history. So if somebody did serve deferred adjudication and the case was ultimately dismissed in California, you as an employer cannot consider that. So you want to pay attention to those kind of details. Now, there are also other limitations, and some cities like San Francisco have their own requirements. So on a city-by-city basis, you may need to pay attention to some of those things as well. And certainly I can help you, or your background screening company ought to be able to help you identify what those state-specific issues are. And then we've got Connecticut. Oops, you don't need to see my meeting notices there. Connecticut has really specific language that you need to include in your criminal history inquiry. And all these state-specific notes are in the handouts when you get them. You'll get all of those. I was so sick of putting slides up full of text. And so, but there are certain kinds of cases that are expunged or erased in Connecticut that you have to have specific language in the inquiry that says, per Connecticut law, you don't have to disclose this kind of information. And so there's a whole paragraph. It's pretty big text that you need to include if you're a Connecticut employer. Then Georgia has a first offender law, which is basically a kind of probation where at the end of the probation, if the defendant successfully completes the probation on a first offense, they can have the case sealed. And so if the case has been sealed, they don't have to tell you about it. And there's really specific things in there, specific kind of language you want to have. But if they're still on probation, then they need to tell you about it. And so you want to have specific language that points that out to them as well. Then in Massachusetts, if you're a Massachusetts employer, if you're in Massachusetts, New York, or maybe California, but especially Massachusetts and New York, you want to pay real close attention to what you're doing because they have developed somewhat confusing at times and less than sensible regulations on what employers have to do. So you want to make sure you follow those. So in Massachusetts, you can only ask about convictions. You can't ask about anything that was dismissed. Then you also have to, as an employer, you can't ask about their first conviction for any of the following misdemeanors. And this is right out of the statute: drunkenness, simple assault, speeding, minor traffic violations, affray, which means I think getting in a fight, or disturbance of the peace. So they have to exclude their first conviction for that. And then if they had a misdemeanor that was more than 5 years ago and they haven't had any other offenses since then, they can exclude those older misdemeanors, which is of concern. So what you're saying is, well, if they were, if the offense was more than 5 years ago, an employer, and it's a misdemeanor, an employer doesn't need to know about it if the person's not been in any other trouble in the next 5 years. So again, in Massachusetts, you want to make sure that you're paying attention to real close attention to the local law. In Michigan, they don't need to tell you about any cases that did not end in conviction. Again, so cases that were dismissed upon completion of a deferred adjudication or something like that, they don't have to tell you about that in Michigan. New York, they've got this whole thing called the New York Correction Law, Article 23A. And if I could do a whole webinar just on Article 23A. And so if you're a New York employer and you need information, reach out to me and I'll help you with that. But they generally, the question, your criminal history question in New York needs to exclude non-convictions. So you only care about convictions in New York. And then you've got some other considerations. You've got to give them a copy of New York Correctional Law, Article 23A, an actual copy of the statute. And it's not a well-written statute, so I don't know what your applicants are going to do with it because it doesn't make a lot of sense, but you have to give it to them. So just so you're aware that you've got those kind of responsibilities. If you're a New York employer, pay attention to that. Rhode Island, again, you can only ask about convictions in Rhode Island. Washington State, if the case is more than 10 years old or they were released from confinement or imprisonment more than 10 years ago, you can't ask about it. So you're basically asking only about criminal convictions in the last 10 years. In Washington, D.C., the District of Columbia, you only ask about convictions there as well. And this is also one of those jurisdictions that prohibits you from even asking the criminal history question until after an offer has been made. This and Hawaii are the two jurisdictions that have that severe of a limitation about when you can ask. And then finally, Wisconsin. In Wisconsin, it's another one of the states that just limits the inquiry to convictions only. So, and so we've got a number of states that limit that. So we've got some ban-the-box states, and we have some states that limit the inquiry to convictions only. We have a whole slew of webinars on our website that cover a lot of these topics. What employers need to know about criminal background checks. That's our Background Checks 101 kind of presentation. High-level overview of the Fair Credit Reporting Act, the Title VII of the Civil Rights Act of 1964 and how that affects criminal history and the cases that are relevant to there, just real high level. Then the background screening policy considerations to avoid discrimination claims. That's the webinar, the name of which I could not recall earlier. That's the webinar that covers all the EEOC related actions against employers in the last several years and the EEOC's guidance to employers on the use of criminal history and some ways that you as an employer can tip your hat to the EEOC's concerns without really creating a lot of new burden on yourself in the employment process. Then creating a criminal history evaluation tool is the webinar where we talk about how to know before you ever know about an applicant's criminal history, whether for a certain job, certain kinds of offenses would be of concern or be even exclusionary. And we've developed a lot of tools for that, and we'd be glad to share those with you. But I think the first step would go look at the webinar. It's recorded on our website. All these webinars, the recordings are on the website for free. But I would suggest to go ahead and download the slides, get those tools. The Fair Credit Reporting Act is the law that will really get you sued in your background check process. It's don't worry about the EEOC nearly as much as you need to worry about the plaintiff's lawyers, and they're creating these class action lawsuits against employers left and right. And then if you're a DOT covered employer and you've got commercial motor vehicles, then we've got a webinar just on what the DOT's driver qualification requirements and the background checks on those drivers, what they need to include in them. And then there's this webinar. So, and we've got other webinars out there on drug screening and other issues as well. So let's go to questions. If you had questions, drop them in the question box and I will try and answer them here. Let's see what we got. There's quite a few. Okay. Some companies do have a no felony policy or no criminal records. That is true, some do, and they're not very smart companies. If I would even in that when I give my presentation about evaluating criminal history, I often hear from companies that say, well, we don't want to hire anybody who's a felon. Well, like in Texas, your third DWI is a felony. If somebody had their third DWI 5 years ago or 10 years ago, should that really exclude them from driving a desk in your organization? Probably not. And so why as an employer, regardless of the legal considerations that related to that, why as an employer would you even want to exclude that person? Why would you make it harder for yourself to find a qualified applicant? And why would you exclude somebody for something that makes no sense for you to exclude them based upon? They don't doesn't suggest that there's any new risk with this or with hiring this person into this role. And especially now, it's getting harder and harder to find qualified applicants. I saw an article in the Wall Street Journal in the last day or two that indicated that the quit rate was high. It was rising. The number of voluntary terminations, people are quitting their jobs to accept other positions, is rising. And so positions are getting harder to fill and people are leaving because the grass is maybe greener across the street. And they're more likely to do that than they were a few years ago. So why make it harder on yourself to fill a job by putting some exclusion in there that doesn't make any sense? Let's see, I'm going through some of these. How would a DWI outside of work be relevant to an accountant that is not impaired at work? I would suggest in most cases it's probably not. If it's strictly an accountant and they never drive, I would be concerned about how recent it was, and I'd be looking for any other conduct that would be out there, and I'd be looking at all my other candidates for the job and see what I've got. But DWI is kind of a hot button with a lot of people. They think some people think it's under prosecuted and some people believe it's over prosecuted. But what it does show, if somebody is convicted of DWI, it does show from the employer's point of view that this person doesn't always have the highest level of safety awareness. And I think it would be fair for an employer to evaluate that, especially for jobs that required a high level of attention to safety or safe conduct. Let's see what I got here. I work in a global retail company and they're looking to remove the box from our application since we're constantly updating it. Do I then need to add this criminal history inquiry form? If so, is there one out there for retail specifically? I don't know that there's one for retail specifically, and I would suggest that that's where you need to get specific, is not in the criminal history inquiry, but on the other side, in what your policy says about how you use criminal history. Because for your retail associates, there are going to be specific offenses that are really of concern to you. Any kind of violent offense, any kind of identity theft, any kind of theft, things like that, those are going to be of concern in a certain period of time and with regard and relative to what the job's, other situations are, which, like I said, I've got a whole webinar on that topic. But I would suggest that your inquiry be as broad as you can legally make it, and then your policy be the thing that winnows out what you as an employer consider. Otherwise, you don't know what you don't know. And there may be offenses that in and of themselves you're not concerned about, even for a retail associate. But as you get deeper into this applicant, you see they've got a whole bunch of these little minor petty things. This person is not going to be our best candidate just because they have all these recent minor offenses that wouldn't exclude them, but we're just kind of concerned because there's a consistent pattern here of not being compliant, not following the law, not following, not doing as they're expected. And but anyway, to answer your question, Rachel, that's where I would focus, is focusing more on the having your policy clearly defined. Again, before you ever order your first background check or even ask your first applicant about the criminal history, develop your policy on what's relevant, what's not, and what's of concern. That'd be the way I would do it. It says regardless of age. If they were a juvenile and the record is sealed, can we ask that? I think that's where earlier I had, after that question, I had an exclusion there, Allison, that said if it's sealed, expunged, or whatever, then you don't have to tell us about it. And so that's how I would address that, just by telling them, if the court has determined that this shouldn't be public record and they've decided to seal it, then I think as an employer, and in most states, you've got some prohibition about asking about sealed or expunged records anyway, so I would just not even ask about those. So let's see, what's this question here? Okay, Lynn. Lynn asks, do you not use the last action date for determining how far back to go? Typically, employers would include the last 7 years based on the last action date, release from prison, parole, probation, etc. You state that you should go back as far as possible, stating as an example, prison 20 years ago and being released from 3 years ago. The 3 years falls within the 7-year reporting period if you use the last action date. Okay, yeah, that would be ideal. But I rarely ever see an application that's that detailed, or an inquiry that's that detailed. If you're putting a limitation, and let me explain what Lynn's saying is, if somebody was convicted 20 years ago, but they were released 3 years ago, they should tell you about that. But if you're only asking about convictions in the last 7 years, and typically that's what I see, or criminal histories that say, criminal inquiries that say, have you been convicted of an offense in the last 7 years or the last 10 years? That conviction happened way back when. So an applicant could honestly say no if they were convicted 15 years ago, or heck, if you ask a 7-year question, have you been convicted in the last 7 years, and they were convicted 7 years and 1 month ago, they could honestly answer no to that question. That's why I say, don't play these games. Let's just ask for everything and then have a policy in place that says we're going to be methodical in how we review this stuff about relevance and all of that. But that way you don't miss anything and you give the applicant a full opportunity to tell you about everything. Our company is a twin city of Texas and Arkansas. For the staffing agency placed on the Arkansas, placing a candidate on the Texas side, do you have any recommendations regarding the allowed timeline for criminal backgrounds to be used in the hiring decision? Okay, you're basically a multi-state employer. And I would suggest regardless of Texas and Arkansas, which off the top of my head, I don't think we've got any unique considerations for either of those states. So it wouldn't be an issue either way, I don't believe. But talk to your background screening company first, but I'd have to go double check their research, but I don't think so. But the bigger issue is what law do you follow? And I would suggest if you're placing, it's where the job is located. And so say you're you're a company in Texas, but you're hiring someone to work in Colorado. Okay. And so you would want to, you know, that position is in Colorado, so you would want to follow Colorado's law when placing that person in that job in Colorado, if that makes sense. That's what the best recommendations that I've heard from the employment law attorneys that I trust and the ones who understand the consumer reporting side of this, the Fair Credit Reporting Act side. And that looks like my last question. Are there any other questions out there? If anybody has any, I'd be glad to answer them. We're at 2:01, which means we're right on time. We will send out an email later this afternoon to you. And what it is, it's going to have a link to a short survey. And the survey is just, you know, questions about how adorable I am, things like that, and what you learned from this webinar. But also, if you'll take the time to finish that short survey, that's at the end of the survey, you'll get your HRCI credit, your SHRM recertification credit numbers, and a link to download the slides, to watch the video if you really want to hear more Kermit the Frog webinar voice, then you can watch the video as well. But it'll all be out there at the end of the survey. And if there's anything I can ever do to be of service to you, I'm an HR guy who happens to own a background screening company, and we really take good care of our clients. We don't do it fast and cheap. We do it really well, and you know, we're a high touch, high customer service company, and you know, if I can ever be of service, it'd be my honor. So please don't hesitate to call us if you've got questions about your current process or want to find out what we do. I want to thank everybody, and I hope to see you at our webinar next month. If you have questions you just didn't get around to asking here, feel free to email me, and I promise I'll get back with you. Thanks a lot. Bye-bye.